Good morning and a warm welcome to all our speakers and the participants. We are here to discuss a very important topic called Equalization Levy. Indian Lawyers Association is an organization working for all Indian lawyers in India as well as out of the country. We are the largest organization working to create the voice of all the lawyers with a presence in 75 odd cities in India. We undertake different events and initiatives by way of our committees who help us put them together. Also, we run a few initiatives on campus for different law schools in the country. After this event, we would be very happy to share more information about what all we do with you on email. So before we start, I would like to give a quick introduction of Mr. Gagan Kumar, who is the founder of Krishnomics Legal and is the president of ILA Delhi. Mr. Gagan brings with him an extensive experience of 2 decades, especially under litigation and advisory aspects of the tax practice. He is a member of Delhi High Court Bar Association, American Bar Association, and is a fellow member of Institute of Chartered Accountants of India. Gagan has been recognized as one of the tax controversy leader by International Tax Review, London, consecutively for 6 years since 2013. He has authored a book on tax prosecutions and on search and seizure under Income Tax Act. Mr. Gagan, over to you for the session. Thank you.
Thank you, Madhura, and a very good morning to all of you. I know it's a Saturday morning and we try to spice it up with the boring topic called Equalization Levy. Just to give you perspective and for those who are not familiar with the topic, at times you would have noticed billboards while driving to your work or back to your home, and you would have seen that these billboards are essentially advertisement, and someone pays for it. And over a period of time, lately, you would have realized that whenever you look for anything or browse anything on the internet, suddenly your timeline on Facebook or Twitter is bombarded with the products which you have often observed or looked at the internet. Now, a question might have come to your mind that how do you get to receive those targeted advertisements? Obviously, someone has been paying for those advertisements, and that is the business model of all these social media companies. Um, so the question is that how do these companies make revenue? And that is how they make the revenue by providing this targeted advertisements. Now, over a period of time, this concept of physical boundaries of a nation, currently what we call is a cyber sovereignty. Where does it begin? Where does it end? No one knows. So from where Facebook comes, where Twitter comes, where Instagram comes, and you get to access, you become part of the global community. You get to share your advertisement to a global audience, or you have the ability to select a particular jurisdiction. Now, the question comes that had it been a brick and mortar shop, you would know where they are taxed. But in a digital environment, you don't know. And over a period of time, most of these companies have started moving their bases to tax efficient jurisdiction. And as a result, a wise community called OECD, they came up with a plan which is referred as BEPS, stands for Base Erosion and Profit Shifting. Now, during this program, they came up with certain action plans, and one of the action plan is to deal with the taxation of digital economy. While tackling this issue, certain proposals came on board, and I'll just very at a very high level discussion, I'll just touch upon that. One of the suggestion was that, okay, tweak the existing concept of permanent establishment. The other idea came on board that, okay, increase the threshold of the permanent establishment. Another idea came that, okay, let us impose a withholding tax on these kinds of transactions. And there was an idea also that, okay, impose a tax on the bandwidth of the internet. Taking a cue, many countries, without waiting for these proposals to take a concrete shape, more particularly Turkey, France, Italy, Spain, UK, and Austria came up with their own form of digital tax, and India also in 2016 came up with this concept of equalization levy. Now, to discuss this interesting topic, we have a great panel with us today. We have Mr. Tushar Jarwal, who is an astute lawyer and a partner at Dutton Manon. And let me also tell you, and I'm taking this liberty, Tushar, though it's not written in your profile, that he was an active member of the litigation team which represented Vodafone before the Supreme Court. And we have another trailblazing lawyer, Gauri Puri. And Gauri is a partner at Shardul Amachan Mangaldas, and she is working mostly on M&A and investment structures. She's a master's from Harvard Law School. She's a Dean's Scholar for a seminar on current tax issues in tax law. And she's admitted to New York State Bar and Bar Council of India. And least but not the last, we have a great stalwart, Daksha Bakshi. She's heading the tax practice at Cyril Amarchand. She brings more than 30 years of experience. She has been recognized by practically every rank and award, Legal 500, Chambers and Partners, Euromoney publication, and the list is short, very long, so I'll not take much time. So with this, we'll begin our discussion. And Tushar, to begin with you, uh, what is the genesis of equalization levy? And if we talk about the Indian law, where do we find the legislative competence in Constitution?
Thank you, Gagan. And before I start, a big thank you to ILA. It's an absolute honor to be here. And also to all the participants. I understand, like Gagan mentioned, Saturday morning, 11 o'clock, we are on a levy. And no one in India has a very good idea about this levy, neither the legislatures nor the taxpayers. I think the first question, Gagan, is very debatable. I think, first of all, the entire tax, the legality of it is very contentious, and it's very suspect. Like you mentioned, if we step back a little and see the BEPS Action Plan 1, what broadly was an ongoing debate so as to arrive on a consensus. There was a mere suggestion given to the G20 and other countries that, of course, the digital economy has to be tapped. There are huge challenges. So therefore, we'll have to gradually move to a situation where the source through which the income is coming needs to be tapped. Of course, the inherent limitation was the treaties. And India as a sovereign has entered into many treaties. And the BEPS Action Plan specifically provided that you have to respect those treaties. Now, there were certain suggestions made. One of the suggestions was, yes, you can contemplate getting an equalization levy, but at the same time, the treaty obligations that India has have to be respected. Now, what happened after the BEPS Action Plan 1 was that there was a committee on e-commerce taxation, which was constituted by the Ministry of Finance. And that committee decided on the earlier avatar of equalization levy. Now, to answer your question, we'll have to first determine in pith and substance what is the nature of this tax. Now, of course, the persons who are drafting this legislation, their understanding doesn't define the nature. But still, if we go back to the report essentially said 2 or 3 very important things. First is, the report categorically said that this tax is not a tax on income. It is a tax on your gross value. Traditionally, the tax is on a net basis if it is a tax on income. Secondly, they said that this is a transaction tax. Now, that is very important. So if it is not a tax on income and it is a transaction tax, what is the nature of the tax? Then they gave an example. And that example that was given, Gagan, was an example which was given when the Constitution's 101st Amendment Act, which introduced GST, had not come in force. So we are at a scenario which is prior to September 16. At that point in time, our constitution clearly provided that if there is a field of taxation which is not covered by the exclusive legislative competence of the state, then under a residuary power under entry 97, read with Article 248, it is the union alone who can introduce a levy. Now, we've seen examples in the past. So if there is a specific tax which has not been spelled out, and now after the Supreme Court judgment of Godfrey, it is very clear that we do not have taxes falling in both the entries simultaneously. There is a mutual exclusiveness with respect to the tax. So therefore, if something which doesn't fall under the state's power, it automatically comes under the center power. And therefore, they said that under entry 97, we can sustain this levy, and this is akin to a service tax. But when this levy actually came, the second avatar, which we are talking about now, then the constitutional amendment had come in. Now, the constitutional amendment has circumscribed entry 97, and it has said that if you are levying a tax which is in pith and substance a GST, then you have to levy it only under a new article called 248A. Now the question arises, what is this tax? Now, if you see the charging section specifically says the tax is on either the online supply of goods or online provision of services for a consideration. Now, this is a tax which is on a transaction. Now, if it is a tax on a transaction today, then it cannot be levied under the residuary power at 97 because it has to be a GST. It should have gone to the GST Council. The proceeds that are coming should have been divided between the union and the states. The manner in which it was coming should have been decided. There would have been a say of all the states. They cannot be mute spectators. That's one. Now, like I mentioned, in pith and substance, can it be an income tax? Of course, that is also a debatable question. But if it does, again, the law is very clear today that we've got treaties. Those treaties have to be respected. And if you see the treaties today, in the context of treaties, there's no question of this being levied because as long as there is no permanent establishment, we are out. So I think either which ways, in my opinion, I feel that this is more akin to a transaction tax. But even if it is an income tax, I think on both these counts, the levy per se is untenable to a certain extent.
Great. That's very interesting observation you made, Tushar, that it's debatable whether it's an income tax or not. So, Daksha, in your view, do you foresee this being subsumed or being incorporated somewhere in the tax treaty?
So I quite agree with Tushar, and it is interesting, and it is also important to note that in that e-commerce committee report, when they suggested equalization levy, they said that because it is not an income tax, it would not fall within the ambit of the double taxation avoidance agreements. So it will be out, and therefore it would not be considered that India is breaching India is breaching its commitments under the treaties. But what is important to note is if you want to look at whether a particular tax is covered under the treaty or not, we need to see the definition of taxes covered in a treaty. Now, if you look at the India-US treaty, the definition is very, very narrow, and it's simply just the income tax. When you look at some other treaties, for example, India-UK treaty, the definition is slightly wider, but it also says that the both jurisdictions have to agree that it is a treaty which is going to be levied. And it says the language there is very interesting. I'll just read that language of the India-UK treaty, which says it is, let me just get that language, that the DTA will also apply to any identical or substantially similar taxes which are imposed by either contracting state and it does not say taxes on income or under the IT Act. So this is it's debatable whether this can be considered similar tax or not under the India-UK treaty. But even if it does, then both parties, both contracting states, have to agree that it has to be notified by both the states. So if you look at it on an overall basis, it's difficult to say that it is covered under the DTA, but at the same time, if it were to be considered as part of taxes covered, and if that particular item is not actually dealt with in the treaty, then again, the question that arises is, can India then go ahead and levy that tax? So that is also a questionable thing. So to my mind, the answer to your question at the moment is it is debatable, but that doesn't mean that someone should not be questioning it. That doesn't mean that someone should not be looking at it to understand, or to have the courts look at it to see whether or not it is covered under the DTA. Of course, as I said, the committee sort of came to a conclusion that it is not covered under the DTA. But I would say that it is something which does need to be looked into.
Fantastic. So it's in a way identical and substantially similar to income tax. So there could be a possibility, and one can possibly argue that though it is a transaction tax, but it's akin to income tax and therefore may be covered under the tax treaty. And
right, because if you see, whether it is fees for technical services or royalty, they are on gross amounts. It's not on the income element of the royalty or income element of fees for technical services. So it just depends on how one looks at it and how one examines it.
Yes, and I think at that point the issue may also arise on the consensus at IDEM that whether the taxes which were discussed at the time of entering into or negotiating the treaty, whether this kind of levy was ever envisaged or not.
Absolutely.
Anyways, to move forward, Gauri, what in your view is the revenue leakage which government intended to plug?
Sure. So I think that I would like to sort of briefly reflect on, the policy underpinnings of it. So essentially, international tax rules have always followed the principle that source countries are countries where value is created. And these countries should have a right to tax these kinds of incomes. Now, for countries like India, what we refer to as market jurisdictions, the whole argument has been, and now globally recognized, that for these digitized businesses, value is created by users. Whether it's your online retailer model, whether it is your social networking model, whether it is your content distribution model, whatever your business model may be, however you may be monetizing that model, there is value, or that profit generation is somehow linked to the user in these digital businesses. In fact, I want to pause here. India's gone a level ahead. If you see our draft policy paper on P attribution, India even argues that even for brick and mortar businesses, market jurisdictions have a right to the profit. So you can't look at the production factors. You also need to look at the market side factors, and therefore it argues that you need a formulary apportionment method for attribution of profits. But keeping that aside for now, and our general crusade towards asserting tax rights based on our markets, I think globally there's a recognition that users create value. It was initially debated, because at one point it was said for these digital businesses, value was being created primarily, by the technologies, the algorithms, the highly skilled employees who were not really based out of these market jurisdictions. But I think there's somewhat a global recognition after the whole BEPS initiative and the papers that OECD has churned out, that users do in fact create value, and therefore countries where these users are located, such as India, they have a right to tax these business profits that are being generated, by several of these online business companies. Now, the issue is that how do you tax this within the existing international tax regime? And I think the challenge there is essentially that the tax rules that were developed were in the context of brick and mortar businesses, where a physical presence was key to be able to tax the business profits of a foreign enterprise. We, of course, have other categories of income, such as royalties or fee for technical services, where if a payment is being made by an Indian resident, then even absent a physical presence, just on the basis of that utilization test, taxation can be extended in India. But these rules were found wanting for three reasons. Number one, that in the existing pay, you have of that MasterCard AR ruling, you sometimes have your Google AdWords, right, Florist, where you try to bring these incomes into these taxation buckets of royalties or fee for technical services, or you argue the website is a P or service created P, but very debatable, always on a thin line. So while that, I feel like that effort on the Indian government is ongoing. I don't think they've given up on that. They've definitely found that it's wanting. It's not allowing them to tax the revenues that they want to tax based on source rights that they believe they have. And if they amended your domestic law, so for instance, you had the significant economic presence test, you had the treaty rules that came into play which prevented them from extending these taxation rights. So the whole idea of introducing the equalization levy is to get over these legal constraints and come up with a very smart mechanism to be able to tax these revenues. I think India's come to a point, as many European countries have, that we can't really wait for a political consensus on this. This is a very politically charged issue. And till such time, we're going to, come up with, I think at least India has like a very catch-all kind of approach. We have some 5-6 taxation measures working together to be able to tax these incomes. So we're just going to introduce equalization levy. And I personally believe that the scope of our equalization levy is much broader than the digital services taxes that some other countries have introduced. So that's basically the revenue or the need for levying the EL and the revenue that we're trying to tap through the equalization levy mechanism.
That's an interesting point you made, Gauri, that while the issue of taxability in case of right florist was dropped, and in case of MasterCard, even a swipe machine was held to be a P. So Tushar, what in your view are we lagging behind from the international community? Because Turkey, France, and other countries have already taken similar steps, or have we jumped the gun and moved ahead and being a torchbearer in this kind of taxation, like the way we have been in Vodafone?
No, I think Gauri made some very pertinent points. I think globally, we are looking at a trade war at this point in time. Now, everyone wants their pound of flesh. Now, the problem is that the process of amending treaties is a cumbersome process. Now, for any sovereign country to initiate that process, you have to bring someone to the table. Now, therefore, the question arises. So if you look at it from that point of view, the fact is that ultimately, like Gauri mentioned, that it is the value, it is the economic presence that has to be taxed. Now, if countries like India and other developing countries keep on sitting and they do not take any measure, what is it are we looking at? It is very difficult to get, especially the US, on the table to get the treaties to be amended and to come to an overall consensus. And any which ways, if there are so many players involved, the consensus is always difficult. Now, if you'll see at an international level, I think US has taken certain unilateral actions, and US in that sense has become, the big daddy, and they've said that, look, whosoever does impose this levy, then you are primarily targeting our companies, because the tech presence largely is the US. Now, you gave an example of France. In France, obviously, France was ultimately arm twisted when the US TR initiated an investigation, and they said that, look, if you are doing this, we'll retaliate, and all your French wines, wallets, etc., which is coming into the US, we will impose huge barriers and duties. So therefore, they relented. Now, for India, again, the USTR initiated that investigation. They've come with a finding, and the finding is very clear that this is discriminatory against the American companies because the same tax is not imposed on the Indians, and of course, this unreasonably burdens the US trade. Now, what is going to happen? Look, I think globally, what we have to see is that today, unfortunately, Gagan, the WTO is a toothless tiger, because even if US were to impose any retaliatory tariffs and they come and they say that, okay, we know India is importing a lot of steel, India is getting jewelry, we'll rub salt in the wounds, we'll now have retaliatory tariffs unless and until you get this off. Now, what can India do? India will have to then rush to the panel. Now, there is no appellate body today. So therefore, if you will see, the entire system has been emasculated by the US. But today, we have a new regime. The Biden administration has come in. There is someone new at the USTR. They are looking at it very closely. Of course, now they understand that the only solution is that everyone has to sit down on the table and arrive at a consensus. So I think the way forward is that for anyone who's aggrieved, I think from an India perspective, you have to approach the courts, because beyond that, it is very difficult to arrive at any solution. That's one way to put it for an international company which is aggrieved. And I think at a global level, US and especially the other countries have to expedite this. Otherwise, we're looking and staring at a trade war.
You said that US is arm twisting all these economies who are coming up with their version of equalization levy. And we, on the other hand, have become fearless. And Daksha, what more changes have we carried out in Finance Bill 2021? We have not been deterred by what US is doing to other economies.
No, absolutely. I quite agree with what both Gauri and Tushar have said. I just wanted to make one more point, and that is that because this is just before I answer your question, I also wanted to make this point, that because this is relating to market economy, rather than market economy, market value, where the market is situated. And while BEPS has been working on this since 2015 till now, the best that they have come out with is Pillar 1. And if you look at what they have come out with, they have come out with the two types of incomes which need to be looked at for the purposes of arriving at what can be attributed to the market jurisdiction. Now, that is a residual income. And this is something that a lot of the emerging economies, developing economies, are not agreeable to. India is also not agreeable to. So as Tushar rightly put it, we won't have people come to table and listen to us until we do something which actually hurts them, or which not hurts them, but which actually shakes them up, because they can't ignore India as a market. They're going to have to work with India. So if India brings on, in fact, I have had some discussions with some of the people who have been part of bringing these provisions in law, that, see, we can't just leave it like that. They're not going to be listening otherwise. So what we have to do is we have to register our dissatisfaction with the manner in which they are bringing the so-called consensus under Pillar 1 to a level which is more acceptable to developing countries, because we do believe that a significant source of that income comes from the market jurisdictions, and what they are doing is going to give us very little, if any, taxation at all, out of any revenue at all, out of the total revenue that they are. And the manner in which it is being put across is really not acceptable to India. So in order to deal with those aspects, India is actually going ahead, bringing in more and more sort of widening more and more its ambit of what it will cover. So, for example, where in this finance bill, it has widened expanded the definition of e-commerce supply or services. And for that, they have brought in an explanation, and it says that online sale of goods and online provision of services will now include one or more of the following, which is acceptance of offer for sale or placing of purchase order, or acceptance of the purchase order, or payment of consideration or supply of goods or provision of services partly or wholly. So it's kind of, completely widening the base. What is worrying? Well, of course, it is worrying for all those who are in this business, and most people are, because as can be seen, it is not only covering the digital goods and digital supplies, but it is covering even physical goods. For example, if someone is ordering books, for example, on the platform, so it is even the delivery of those books which is getting covered in this digital taxation. Then if you are booking a hotel, the entire booking of that hotel, because that you won't be using that hotel in India, there is no allocation being done, like how it is done in permanent establishment, that only the income which is allocable to the activities of permanent establishment will be taxable in India. There is no such allocation. The entire consideration for doing the hotel booking, even though the hotel is not going to be used in India, if the hotel is outside India, or the vice versa, it is still going to be considered taxable. Then another provision that has been brought about is the definition of specified circumstances. That is also has been expanded. A consideration for sale of goods, irrespective of whether the e-commerce operator owns the goods. So this is just exactly what I was explaining. Another thing is consideration for provision of services, irrespective of whether the service is provided or facilitated by the e-commerce operator. So nothing is left out. Everything is covered. And there are also several other procedural and compliance related provisions which have also been brought about. So there are significant expansion which has been done with regard to the ability to levy equalization levy on the transactions which actually are carried out on digital platforms, whether those transactions are related to physical goods or digital goods, or physical services or digital services, is irrelevant. The spectrum is quite wide.
So essentially, to shake the pillar, we have taken a bolden step of widening the scope. And as they say, bhai bin hot na preeti. So unless we have something to scare them off, they would not come on table. But just to, as a follow-up point, you said that tangible goods and supply of services would also be covered. But I think there is already an exception that to the extent they are covered under income tax, there would not be an equalization levy. Am I correct?
That is true, but the thing is that if the platform, which is outside India, there is no way otherwise that platform would be considered to be covered under the Income Tax Act, or essentially under the treaty. For example, a platform which is a server which is outside India, it is not, a platform is on a server outside India, then there is no way that that will be covered under the existing definition of income, which attracts taxation in India. So it is all of those transactions which could not be taxed because those businesses did not need physical presence in India. They could do their business without having any physical presence in India, and they could do it significantly. What Gauri was pointing out is that a significant amount of business is happening like this, where there is a revenue being earned from the market jurisdiction, which is remaining outside the scope of market jurisdiction's ability to tax that revenue. And the current provisions of international taxation do not seem to lend them to seek the market jurisdictions to claim that to have source in their jurisdiction. So this is what is being tried to be addressed by making it so wide.
Tapas, you wanted
May I,
to make some
Gagan?
point, I guess. Yeah, please.
Yes, actually, I mean, after Daksha has really illuminated this thing very well. I just wanted to point out two things here, that the scope is being expanded beyond what was ever conceived. For instance, sale of goods was always subject to taxation only in the case of a presence of permanent establishment in India, otherwise it was not taxed. Now, apart from seeking to tax a sale of goods, because when you are ordering goods online, the seller is not being taxed, it's the platform which is being taxed. The platform plays the role of a facilitator. So there could be another actual seller, but the platform is going to face a tax on the basis of the gross value of the sale. So there is a huge distortion in the tax that is being levied and the sales turnover. And there are certain service companies like the computerized reservation system companies, which are all now waiting for the decision of the Supreme Court. The final hearing is listed. Now they will all get covered under this equalization levy, because you may book a flight ticket sitting here for traveling from London to New York, and the booking is being done from here. It will not get covered under royalty or fee for technical services. If it doesn't, then it gets taxed under equalization levy. So it creates, opens up a huge Pandora's box.
Yeah, that takes me to Gauri on the next question. Gauri, how practical do you think the recovery and the enforcement provisions are going to be?
Great question, Gagan. So I think I'm going to take this question two parts, right? So one is the technical piece of it, and then the other is the practical piece of it. When I refer to the technical piece of it, that's really referring to what are the teeth given in the statute itself to recover these taxes. So for instance, you have all the income tax recovery provisions which have been made applicable. In the event that there is a failure to pay equalization levy upfront, then there is an interest exposure of 1%, a penalty equivalent to the amount of EL which applies. If a statement is not offered, the assessing officer can give you a notice to say file a statement. But the assessment proceedings themselves, so the 143, 144 kind of assessment provisions that you have in the Income Tax Act, those haven't been borrowed in equalization levy. And therefore, some practitioners are taking a view that in the absence of the assessing officer having the power to pass an order determining your equalization levy ability, I mean, how will recovery happen? So to my mind, these are more or less technical issues. One can argue that if there's a charging provision, recovery will automatically follow. And if there is a lacuna in the technical provision, all they have to do during the next finance bill is just apply those income tax provisions to the equalization levy. So I don't think that is a roadblock. That's more of teething issues, which they can always sort of equip the statute with. Like I said, the recovery provisions currently allow you to recover taxes from any assets that a non-resident may have in India. They, they have the ability to invoke rep assessee proceedings, etc., etc. But I think the bigger concern is the practical piece of it. Here you're asking foreign companies, many of which may not have any sort of physical presence in India or any kind of presence of assets in India, to come and comply with your laws when you really have no way of verifying or vetting whether they're doing so. So you're to a very large extent relying on self-compliance and the risk, the reputational risk, and a smell test of sorts to ascertain that whether there is a foreign enterprise who has that degree of interactions, digital interaction with Indian users, that whether they should be taxed in India or not. So the recovery or the enforcement itself has to be seen in this context. Where do you get that information? Now, if that foreign enterprise has some sort of a subsidiary in India, a back office or whatever, you may have like the power to carry out survey provisions. You also need to bear in mind that they've extended the income tax provisions by way of which you can seek information from other regulators. And currently, when you're, this whole reform that's happening, it's not really happening in the tax space in silos. So you have the PDP rules that are coming, you have the intermediary guidelines, you have those e-commerce rules. So a lot of regulators are seeking information, and compliance is happening across the board. So that's another way in which that they can get information. But again, you see the scope of EL. It goes to, the minutest of transactions, even at a granular level, which could be taxed in India. For instance, right now, the concern is that even if I place an order through an email or a communications platform, that could be subject to EL. So how do they monitor and enforce recovery to the level that they have envisaged? I think that's going to be a key question, key issue. Another Achilles heel is that, we have these tax information exchange agreements, we have DTAs. Typically, if you see the language, they're limited to the taxes covered under the treaty. Now, if you're arguing that equalization levy is not covered under the treaty, then how do you, obligate another country to share information with you under that treaty? For instance, if you want take assistance in tax recovery proceedings, because you yourself are arguing that these are not income taxes and therefore these taxes are not covered by the treaty, so to speak. Of course, it has to be evaluated treaty to treaty, but that's again an issue. So I think from a practical perspective, recovery and enforcement is very large driven by self-compliance by many of these foreign enterprises, them coming to the fore themselves in light of the reputational concerns, and just like I said, a general smell test that the regulators have in the sense of what are the key websites that are currently operating in India, what are people really interacting with. I think that's essentially the hook they have currently.
Gagan, you're muted.
Sorry, thanks. So I'm saying that at this point, I would come to Tushar. Tushar, have we digressed from the objective, because the idea was to tax the income on source basis, and people or the companies who were making money from the market, that is India, were not paying tax because they didn't have any fixed place or any permanent establishment in India. And from there, the way we have currently formulated the equalization levy, is it becoming a cost on the customer, or is it partaking the character of a custom duty as such?
Yeah, I think these are very relevant points, and that's what the gentleman here also mentioned. If we look at the original draft, which was obviously sneaked under the carpet after the debate in the parliament was over and we were just getting into a lockdown the very last day, we got, of course, the text of this the bill, and then obviously it became an act. Now the issue, I think, Gagan, is that initially when the draft came, everyone thought this is a digital tax. Now the distinction between a digital, non-digital attribute has completely been eliminated, like Tapas and Daksha mentioned. So therefore, now let's look at the complete universe. Today, our constitution says that if you are a good, you need to be XYZ, and anything other than good is a service. So therefore, the complete universe is either a good or a service. Now, if you go to the definition says you should be an e-commerce supply or service. And then they say that it should be online. Now, initially, when it was online, everyone was taking a view that ultimately what you have to tax is something which is digital in nature. Now, to the extent you come with a retrospective clarification, and obviously you will say that it is clarificatory in nature, you have said that any of the attributes in today's age, if that is done over a digital medium, the levy will apply. So what is left? So absolutely, if suppose I am saying I have to order, say, like a tennis racket, maybe for someone, then of course the racket is going to be imported into India, but I'm not going to pick up the phone and call him and say that send the racket.
मेरा नाम सरोजिनी है ना इसमें, सरोजिनी और गौरव.
So therefore,
नहीं सरोजिनी दोनों का नाम है, सरोजिनी गौरव. मैं सरोजिनी का देता हूँ आपको, ठीक है?
I think there's some disturbance. Please, can you mute? Yeah. So therefore, yes, I think now this tax has become very adventurous, and there's not been a lot of thought that has gone into it. And this is what Gauri has also highlighted, because if you'll see, even in the context of assessments, while it appears that everything is on a self-assessment basis, because the section, if you'll see, only provides for a processing, and a processing is always computational. So therefore, inherently, there is no mechanism provided where someone would say that, look, if I, on first principles, are not covered by this levy and the government feels you are covered, then what do? You don't have an assessment. It's only a computation on the basis of the statement that is made due by you. So therefore, I think, look, this is the main challenge that everyone has made. And if you see the international community, I think no one wants to bell the cat, but everyone still does understand that because of, the sheer size of the Indian market, they cannot ignore India. The levy today looks at a 2%. So more or less, it's not that hurtful because it's can be a transaction tax. It has the ability to be passed on. But in certain scenarios where you are a marketplace, ultimately imagine a share of income which is never forming a part of your accounts. Ultimately, you are liable to pay on it. There are, larger issues because all of this becomes confiscatory. But under our constitution, Article 19 is not available to foreign assessees. So therefore, I think this next 20 odd days, Gagan, will be very crucial, because if this explanation comes in law, I think definitely we are looking at a challenge. So therefore, the government has to decide what has to be done on this explanation, because this explanation, to my mind, is so expansive in nature that it now gives this levy completely a very different color. Now, on your question of customs duty, look, as I said, the manner, if you will see an attribute of a tax, and this is what Godfrey has said, and this is what I mentioned earlier, that you will have to see the taxable event, you will have to see the person on which it is levied, and what is the object. Now, what is the object here? The question is the object an income? If the object is the income, we are very clear that this is completely not liable because of the treaties. If the object is a transaction, then yes, there is a tax already on each of these. So if I order something online, it comes into India, I'm paying a customs duty. If it is a service, I'm paying a GST. Can there be a double tax? Our constitution doesn't forbid it. There can be a double taxation. But the question is that if it is a GST, did you take it to the council? Did you hear all the states? Are you giving the share to the states where the consumer is sitting? So I think these are big, large questions for which we will not have an answer here. You'll have to watch what is happening at the international level. You'll have to see how the big ones who are getting impacted think of challenging it. But yes, I think we should wait for the act, and then there will be some clarity. And ultimately, I would see this matter to go in courts. And it has happened. We've taken one of the matters to court, which was also an approach which was completely unreasonable by the department. So I feel that definitely we'll see something happening after the act.
So talking of the act, would it continue to remain like a finance act, the way service tax remained finance act for the longest period of time until GST came? Or do you think this will become a formal act in its own sense?
So this is also very interesting because, if you remember when the finance minister Manmohan Singh was there, I think in '94, he said that, look, if you see India, the GDP, 40% is services. So therefore, I don't see any reason why we are not taxing services. The entire Europe, US, etc. is taxing. And then he obviously went to the fields of legislation and he saw there is nothing. So he said that where should I tax it? So then they go to 97. And at that point in time, it initially came on 3 services. So therefore, whenever there is a half-baked legislation, usually there is a draftsman sitting there who really doesn't want to apply a mind and create a new act. So they start by way of amendments in the finance bill of that year, convert it into an act, and thereon no one has the time or effort to convert it into a new legislation. So this is what happened to service tax from 94 up till 2012. This is what's happened to SCT. This is what has happened to all the cesses. So therefore, at this point in time, I really don't see, because they've already said this is a temporary levy till the time the larger questions are decided. So I feel it will go on, but the form really doesn't matter. The fact of the matter is that irrespective of the name that has been christened, irrespective of the form in which has come, this levy today really needs to be questioned before a court.
Fantastic. So Daksha, you have in your long career have advised and interacted mostly with multinationals or the foreign companies. What, in your view, this act will do? Will it scare them off to do business in India, or will it encourage them to come and physically set up shops in India?
So again, I'm going to answer this question also in 2 ways. One is people who look at India with a with a very skeptical mind, and they only want to make investment in India. So those who only want to make investment in India and make money out of those investments, for them, this may not be a very important or relevant or a deterrent levy. But also, if they are making strategic investments in India, they are making investments in companies in India. Again, that is also something which is contributing to their income by way of investment rather than by way of dealing with customers or doing business in India. So for them, I don't think it's going to make too much of a difference. But there is a whole lot of other people who are looking at India as a market to service the consumers in India. And it's a huge market. It's a huge market and it's growing. The lower middle class is becoming middle class. The middle class is becoming, getting more ability to spend more money on items which are not essentials anymore. They may not be called luxuries, but items which are being sold by these international organizations, international sellers. And international sellers, how do they reach the Indian market? The only way they can reach the Indian market is through these e-commerce platforms. So e-commerce platforms are becoming very relevant for those people to access the Indian markets. Now, if the e-commerce platforms are going to be taxed like this, what's going to be the impact on those people who want to reach the Indian market? They are not getting impacted. Who is getting impacted? As someone pointed out, it's the platform operator who is getting impacted, because the entire consideration is flowing to the platform operator, and it is the platform operator who is going to be making the payment. So the platform operator obviously is going to have to pass this tax as a cost on to the Indian people, Indian marketplace, meaning that to that extent, it is the Indian resident who is actually paying the tax, not the people who are making money out of it, if at all. So it's really, in that sense, defeating that purpose, that you are actually taxing them. You're not taxing them, you're taxing Indian people. Secondly, it is becoming a little more expensive for them, for the Indian people to access those goods. So when that is happening, what happens is that those people start looking at the ways in which to increase their competitiveness. For increasing their competitiveness, they would now start restructuring themselves and reorganizing themselves, probably, to, first of all, split their businesses across several jurisdictions, maybe, so that they don't cross the threshold of $670,000 in any one jurisdiction, any one platform, or they may even flip it around and come into India and do it. And that may even be the reason for that may even achieve the objective of bringing more investments into India, creating more marketplaces in India, creating more revenues which are actually taxable in India. So there are several ways in which this is going to be impacted. But what I see is that the international businesses who want to access the Indian markets, they are just going to treat it as an additional cost and pass it on. They are not going to simply because there is this deterrent, so as it were. I don't believe that they are going to run away from India, because it's too huge a market to be to run away from and not to be able to tap. So in that sense, I think that there will be a significant disruption in the manner in which businesses are done on these platforms with India, in India. But I don't believe that it is going to reduce any interest of those people in India.
So essentially, India is too big a market to be ignored by any international business community. And while at the same time, we don't want to be arrogant of our market size, but at the same time, the concept of source-based taxation, that yes, we have right to tax those companies who are making profits out of India. What suggestion would you make? And this is a question to all three of you, Tushar, Gauri, and Daksha. That what suggestion do you think should be made in terms of tweaking the equalization levy, or should we come up with a completely altogether new procedure, or should it be part of the Income Tax Act? Gauri, will begin with you.
You want me to start? Should I start?
Yeah.
Okay. I think, as we've all spoken today, nobody's really contesting our country's right to tax value, which we believe is legitimately created in India. I don't think that's an issue. We all recognize that. But I think there has to be some method to the madness. Currently India's had a very all guns blazing and a grab all approach. So in 2016, we introduced the significant economic presence test in our domestic law. I understand that, the tax treaties prevented us, but from, fully implementing it, but that was introduced. Then we introduced the 6% equalization levy, which was capturing all online ad revenues. Then there was a draft paper on P attribution, which went on to say that we've never really subscribed to OECD's authorized approach towards profit attribution, which relies on transfer pricing. We believe that market jurisdictions deserve their fair share, even in brick and mortar businesses. Therefore, a formulary apportionment method approach should be adopted, pursuant to which the market jurisdiction gets a share for that, for the sales factor. And in case of digital businesses, you also add another user factor. So that was number 3. Then we came with a 2% equalization levy, which was, I think, bigger than the problem itself. It is so expansive, as Daksha has explained today, as Tushar explained today, that we, right from the fact that it's capturing traditional brick and mortar transactions, and to the fact that the revenue, currently the tax base itself is unclear. You're taxing the gross merchandise value as against the commission that's being retained by several of these online marketplaces. So it's all guns blazing right now. And if you ask me what is the coherent policy of the government, how is it perceiving taxing digital businesses, I don't think I'll have an answer. It just seems like get whatever you can. Additionally, you also have your existing tax rules, where you have withholding on royalties and withholding on fee for technical services and server fees and website fees. And like I mentioned earlier, we also have changes coming in other regulatory norms. So pursuant to the PDP rules, you have you have to appoint a compliance officer or a grievance officer. Pursuant to the e-commerce rules, you may need to set up a local office in India if you want to carry out e-commerce business. Under the intermediary guidelines, again, you have to have a nodal officer. Does this create a PE? So it's a scattered approach. Doesn't seem, like Tushar said, a very well thought out mechanism. Is what is it? What is the problem am I trying to solve? Is equalization levy only a transient measure till a global consensus is achieved? If it is, does it need to be so big and so expansive? Because as we did with the indirect transfer rules, it always feels like we legislate very quickly and then we start thinking later and try to fix nits as we go along, and that sort of gives us sort of a very bad name as far as tax certainty processes are concerned globally. Currently, for a bona fide foreign enterprise, everybody's not sitting there to evade taxes, who's looking to comply with your equalization levy. There are so many of gray areas that you don't know how to do it. Like I said, your tax base is unclear. It's not you don't know what digital facility means. Can an email trigger equalization levy? When you talk about online ad revenues generated from a non-resident for targeting an Indian resident, what data do you need to be able to comply with that kind of laws? How is an e-commerce operator supposed to track the residency of individuals looking at it? What do you mean by targeting? Sometimes advertisements are given to target a particular region, not a particular country. How do you attribute the India piece? So I think it's there has been a haste in a way to have to implement these laws and give teeth and probably show muscle, whatever the case may be. But there has to be some sort of a slowing down effect. There has to be a policymaker who's thinking on how are these moving pieces all tying in together. What is our priority? What is the problem are we trying to solve? Are we fixing things which are not a problem right now? So I think that it's not about what suggestions you can give to the government to what to do more. It's really to fix what you have done so far, so that compliance for a bona fide foreign e-commerce operator is easy, and people who are implementing it on ground, whether that's the tax practitioner community or the tax administration, they know what you're doing. Currently, I feel like nobody knows what they're doing. It's just a lot of discussion and debating, but we've just been left with all this ammunition, and we don't know which way it'll go.
That's great, Gauri. And as you said that there are laws, and accordingly the equalization levy need to be drafted in that light. So Tushar, we have data protection law also coming very soon, and to my mind that would also have a bearing on equalization levy. What suggestion do you make that the law should take its new shape?
Look, I think, Gagan, I have been very clear that a law must be strictly as per letter. Now, today, we've seen that irrespective of the nature of this tax, it is not falling within the constitutional scheme of our country. So therefore, in these circumstances, where the international world is looking at you, and this is primarily a tax which is targeting the international community, you are looking at more FDI investments, you are laying down the carpet for the world. I think the manner in which this has been introduced, and in the brazen manner in which, in the garb of coming out with a clarification to mitigate the rigor, you are expanding the levy, obviously speaks volumes. So in my view, I think this was not a step in the right direction. But at the same time, what does India do? Now, that's the important part. That can we just sit and lose onto the revenue? And is this only India, or are the others also following suit? Now, on that, I think, like I mentioned again, this is kind of a trade war scenario because no one is arriving at a consensus, and you really want to get people on the table. So, I think these are all steps being taken for the purposes of getting everyone on the negotiation table. But I think the government should also look at the pinch and the arbitrariness which is being caused by the manner in which this levy has come. It is very difficult to set up processes for an international taxpayer. There is no clarification. This is a tax which per se appears to be confiscatory. There is no delegated legislation. There is no forum where you can go and liaison. There is no advocacy. The the policy makers have not stated anything. It's the bureaucracy which is running the show. And we all know there are officers coming here and there, and their interpretation ultimately is becoming the law of this country. So I'm very sorry with the manner in which this is happening. This is a law which affects international taxpayers. Ultimately, you should have discussed this in the budget. This should have been put before the House. You look at the will of the people, decide the manner in which it has to come. So therefore, I think the whole exercise is done in such an arbitrary manner that leaves a very bad taste. Now, what is the way forward? Look, like Daksha mentioned, I think even though it appears to be 2%, but it's very circumstantial, Gagan, because look, 2% is on a gross value. So if I'm making a 10% profit on, say, 100, ultimately I'm paying a 20% tax. So therefore, if you are paying a 20% tax, this is a big tax. But for someone who has a higher margin, maybe they are good. That's what's primarily happening in services. But the fact remains, if the tax per se is unsustainable, it is unsustainable. I think there is where the buck should end. And that is very clear with this levy.
So, Daksha, many countries have followed the suit, and at least one thing we all are in agreement that these companies cannot go untaxed. So, in your view, what could be the suggestion to streamline the process and to mitigate the compliance issue and the enforcement issue?
Well, again, I'm going to have to go back to what has been happening for the last 20 years. India has been, sort of crying hoarse, saying that, what everyone is doing, we are losing our revenue and we are not going to continue to lose revenue. We want to. The same thing happened for software imports and all of that. You would remember the technical advisory group set up by the OECD, who looked into 28 categories of transactions and analyzed whether they were taxable in the jurisdiction where the services were provided or not, and whether they were treated as services or business or goods, etc. And category 2 was the one which really was the critical one, which India disagreed with and said, no, India said that it is taxable in India. So that really brought a lot of the other categories within the tax net in India. That is what they wanted to do. And they have been, if you look at the judicial, all the litigation that we have been noticing since then, it's all surrounded, around that particular issue. India is finding it difficult to accept not to have to be able to tax it. So while I totally agree with everyone else that this looks like a levy which is completely, there is no sort of proper procedure, etc., no legal backing, no proper thinking. And that is one thing which is very, very hurting, that there is not sufficient level of thinking from all directions. And to my mind, I would say that India could make some sort of a noise by giving a token equalization levy, reducing the scope that it has right now put out, which is absolutely obnoxious to my mind. I'm sorry to use that word, but I would say that it is. You can't really tax everyone in the world in this manner. I would say just a token 0.5%, not 2%, not 6%, 0.5%, and and remove all these additional things that they have brought in, but just keep it to digital, because that is where India started off saying that we are losing out revenue. You're losing out revenue on the entire digital economy. Yes, you do have a right to go ahead and ask for something. About the 0.5%, you will bring everyone closer to listening to you. Don't drive everyone away. Look at the gap between what India wants to levy the tax on and what the Pillar 1 is saying. The gap is so huge, there is no way of coming anywhere closer to agreement. Can India live in isolation like this? And here's where I agree that it seems more driven by the people in the revenue department who want to find any which way to increase their revenue, since they can't increase the tax rates on the residents or on the people who are paying taxes in India. They're just finding other ways of creative ways of raising revenue. But it just needs to be thought through very well. And I would certainly think that it should be kept as a token levy at the moment, till such time that the consensus is built, and act more creatively, more actively, more with understanding, reasoning, legal backing, procedural backing, and everything at the international forum to bring a consensus. India does actually have a very good rapport with a lot of the developing countries, and a lot of developing countries are looking up to India to find a way of plugging their revenues also, which are getting lost. But this is, in my view, not the way of doing it. Do it in a manner which sounds reasonable to the world, not unreasonable. And this, with this year's changes which are brought in, is, to my mind, unreasonable, to say the least.
So just to conclude, I have a suggestion, and at ILA we'll try to consolidate all those things and try and send it to the government. To my mind, and I to a certain extent agree with you, Daksha, the simplest way would be to impose a TCS on digital tax, make it amenable to treaty benefit, and get over with the equalization levy. Tapas, I'll catch you here by surprise. Concluding comment and vote of thanks you have to give.
Yeah, so I'll come to the vote of thanks, but I had two thoughts when I heard Gauri refer to the teeth of the legislation. So if I have a minute, I just wanted to go back in history, that if you don't have teeth, then you bite at everything. As we see with the babies. We had the same problem with the TDS provisions when government was very active with TDS compliance in 1995. Before that, they were sleeping over all TDS provisions. Then they started this process of TDS verification without there being any provision for that in the taxing statute. So there was no assessment process, nothing was prescribed. So a TDS verification process was never contemplated in the Act. That created a whole Pandora's box about limitations and other things. Some courts came in to say 4 years is a reasonable period, and very few people actually questioned any assessing officer that under what provision are you asking for these details. And whenever we did, they backed out. Then 200A was introduced in 2010. So for 15 years, now equalization levy will have same problem. Equalization levy is a tax on non-residents and a harassment on residents, because you have to collect and deposit to the government. Now, if you own a house and not a very large one, and you're dealing with a Google, then for the last 2 years, companies are facing this problem that they are effectively paying it from their own pocket. So the international stronger players say that give me my 100 rupees, you pay your 6 rupees or 2 rupees from your pocket. So that's another issue which has to be well crafted so that if there is a law, this is the compliance that needs to be done. This is how the formalities are to be there. That has to be thought through. And I entirely agree with all this suggestion that Tushar and Daksha also said. This is a bureaucracy-driven law. Kind of short-term process. Somebody decided one bright morning that if you buying a flat on installment, it's a service. It was never contemplated earlier. One fine day it became like that. So equalization levy is gradually moving in that direction. Anyway, having said that, let me thank you, Gagan, for coordinating this discussion in a beautiful manner and in a very your inimitable, sober and sensible style, and to Daksha for illuminating with her decades of experience, Tushar for, I was very impressed when he went back to the history of service tax in 1994 and started with that, so that moving, establishing a connection is very important, which made this whole discussion really worthwhile and really enjoyable. Gauri for her brilliant exposition to the international practices and other things, and to all of the participants for being so quiet and undisturbing. Thank you all.
Thank you everyone, Tushar, Gauri, Daksha, Tapas, and all the people who spared time to join this session. And I tried to cover up all the questions which I received on the chat box. So thanks a lot. It was a lovely discussion. Have a great day.
Thank you so much. It was a
Thank
pleasure.
you. Thank you for giving the
Thank you.
opportunity. Thank you. Bye.
Bye.